attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a Lawcast series discussing mergers and acquisitions. In the last two Lawcasts in this series, I discussed the responsibilities of the board of directors and in particular their fiduciary duties related to merger and acquisition transactions. Today, I am continuing with a brief review of the leading Delaware case law on point. Stemming from the landmark case of Revlon Inc. versus MacAndrews and Forbes Holding, once a board of directors has made the decision to sell or merge the company, it triggers additional duties and responsibilities commonly referred to as the Revlon Duties. The Revlon Duties provides that once a board has made a decision to sell the company, it must consider all available alternatives and focus on obtaining the highest value and return for the shareholders. A board of directors in a Revlon situation is, in essence, an auctioneer, seeking the best return. However, although the premise of Revlon remains, later decisions do take into account the reality that the highest return for shareholders is not strictly limited to dollars received. In the earlier case of Unocal versus Mesa Petroleum, the court found that the board of directors may take defensive measures in the face of a hostile takeover and may consider the preservation of corporate policy and effectiveness of business operations in defending against a takeover. However, once the board makes the decision that it is going to sell or break up, then the Revlon duties take over and preservation of corporate policy and operations is no longer a consideration. In the seminal case of Smith versus Van Gorkum, the court found that the board was grossly negligent where it approved the sale of a company after only a few hours of deliberation, failed to inform itself of the chairman's role and benefits in the sale, and did not seek the advice of outside counsel. Similarly, in Seedy & Company versus Technicolor, the court found that the board was negligent in approving the sale of a company where it did not search for real alternatives, did not attempt to find a better offer, and had insufficient knowledge on the terms and of the proposed merger agreement. On the other hand, the court in CompuCom Systems, Inc. upheld the board of directors' business judgment decision even though the transaction price per share was less than the market value, as the board showed it was adequately informed, acted rationally, and sought better deals. Similarly, in Family Dollar stores, the court continued to apply the Revlon duties but supported the Family Dollar store's decision to reject Dollar General Corporation's higher offer in favor of seeking a shareholder vote on Dollar Tree's offer, competing offer. The court found that the board properly considered all factors, including the evaluation of the relative antitrust risks of selling to either suitor, and the court really focused on the process. The court upheld the board's process in determining maximum value for shareholders and that such determination is not solely based on a price per share and price per share value. As I've discussed in prior Lawcasts in this series, the most important factor in determining whether the board of directors has met its fiduciary responsibility is the process undertaken by the board, including attendance at meetings, the number and frequency of meetings, knowledge of the subject matter, time spent deliberating, advice and counsel sought by third-party experts, requests for information from management, and requests for and review of documents and contracts. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.